next case to come before the court is Capital One Bank et al. Versus Karen L. Jones. Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you wish to do so, when you take the podium, just let me know, and I'll do my best to keep you apprised of your time. The arguments are being visually and audibly recorded to be posted online, so if you would keep your voices up and remain behind the podium, it would be appreciated. Don't use the names of any children, which is not applicable in this case, or victims, which is also not applicable in this case. But we have read your briefs, and we are ready to begin when you are.
Good morning. May it please the court. I'm Anand Misra on behalf of Ms. Jones. I would like to reserve 3 minutes for rebuttal. I'd like to start by acknowledging that summary judgment does serve a useful purpose. However, it is simply not appropriate in this case. Here, the trial court overlooked key evidence and it weighed evidence in favor of M&P. It also made some key errors of law, and I'd like to highlight a few of those issues here today. First, this case, when it was filed, was time-barred, and there are really two principal issues there. First is, where did the cause of action accrue for purposes of the Ohio's borrowing statute? And second, is there a sufficient writing here that for application of a statute of limitations for a written contract? So the trial court found that the cause of action accrued in Missouri, and it did so solely based on a P.O. Box address listed on an account statement. It ignored evidence that payments could be made by other means, and the fact that in this case, payments were all made electronically online. The court also ignored evidence that the payment address could have been that of a payment service provider rather than of the bank itself. So this superficial focus solely on the P.O. Box listed on account statements violates the principle stated by the Ohio Supreme Court in Taylor and elevates form over substance. In Taylor, in identifying the place of accrual, the Supreme Court said, the Supreme Court focused on the place where a creditor would suffer an economic injury from the non-payment. We respectfully ask this court to clarify that while the place of payment may indicate the place of injury, the trial court's analysis must not stop there as it did here, but it should consider all the evidence in identifying the true or actual place where the injury takes place to the creditor. Here, the place of accrual would be in Virginia, a fact that is noted in Taylor as well. Now, moving on to the requirement of written contracts, the trial court did not consider the principles laid out by the Ohio Supreme Court in Reyes and for the application of the statute of limitations for written contracts. We again respectfully ask this court to clarify that these requirements in Reyes must be applied for purposes of revised code 2305.06. In this case, these requirements have not been met, and we've discussed that quite extensively at pages 16 to 24 of the appellant's brief. On a related issue, since Virginia law is implicated here as well, the requirements for written contracts under Virginia law have also not been met in this case. M&P insists at its brief, at page 9 of its brief, that there exists one document referencing and incorporating the others that is signed by the cardholder, and that this document contains all the essential terms of the agreement. That's the standard that they say applies under Virginia law. Unfortunately, there is simply no such document in evidence in this case. And the only document that is alleged to be signed by Ms. Jones is an application form which does not reference or incorporate other documents, and it certainly does not contain all the essential terms of an agreement. The second principal issue in this case is that the identity of the plaintiff itself is unclear. And this, in turn, raises issues of the real party in interest and standing. So on the date this lawsuit was filed, there was only a registered word mark called Capital One Bank. And this word mark is owned by a company called, it's Capital One Financial Corporation, which is not a bank. This same corporation is also identified on all the credit card account statements as the owner of the mark Capital One, which is used all over the account statements. Ms. Jones submitted evidence that Capital One Bank itself has asserted to a federal court that it was not an entity, but simply but solely a trade name. The trial court ignored that evidence as well. Now, MNP claims that it made a mistake in identifying the plaintiff, and that the real plaintiff is Capital One Bank USA NA. So we've called Cobasana, is how we've been referring to it in short. Yet there has never been an amended complaint to correct this alleged mistake. Ms. Jones has pointed to other evidence challenging the credibility of this claim of mistake. And the trial court simply seems to have made a credibility determination in favor of MNP on this point. Now, beyond the identity, even if Cobasana were the plaintiff in this case, it simply fails the test or fails to meet the requirements for a real party in interest or for standing. It presented in depositions its representative, Amy Amesler, unequivocally testified that Cobasana had no right at all to the receivables, and it had no right to any money that might have been collected in this lawsuit. The only claim was that it's a collection agent for the owner of the receivables. However, the document on which this agency claim is made is dated 2010, which is well after this lawsuit was filed in 2009. And therefore, that document cannot support a claim of standing in this case. In conclusion, in addition, the trial court did not go through an analysis to determine whether the requirements for a real party in interest had been met in this case as well. And so in conclusion, we submit that the trial court exceeded its role at this summary judgment stage, and therefore Ms. Jones respectfully requests that this court correct this error and remand the case for a trial by jury. Thank you, and I'm ready to answer any questions that the court may have.
All right.
Thank you.
Good morning. My name is Maya Jaron, and I am here on behalf of appellee and counterclaim defendant Morgan and Pottinger. I'll call them MNP just for sake of clarity. And I respectfully ask that you affirm the trial court's decision granting summary judgment in MNP's favor. So just by way of brief opening, the FDCPA, it was intended to protect the rights of both the debtors and the creditors. Right? The courts have repeatedly interpreted the statute in a way that preserves the rights of creditors to pursue their legitimate claims, which is what we have in this case. So although Ms. Jones has really attempted to confuse the issues, this is it's a simple case. It has simple facts that are mostly undisputed. So we know that Ms. Jones received a credit card application in the mail from Capital One Bank. That solicitation package in total, it included her interest rate, it referenced an acceptance certificate, and how do we know she got that? We know she got it because she signed it. And that has been produced in evidence and authenticated by affidavit. She used the credit card. She went to Fashion Bug, she went to Things Remembered, she took out cash advances. She doesn't dispute that she used the card. She doesn't dispute that she got periodic statements, which she did, and she made the payments. Then she retained a debt consolidation company, and she consciously decided to stop paying her credit card bill. And that's when M&P filed the collection action on behalf of Capital One. But I also want to note that Capital One didn't sell the debt here. So we're not dealing with a third-party debt buyer. We're dealing with the original creditor, Capital One, who extended the credit and who owns the account. Now, Ms. Jones' first assignment of error fails for several reasons. Now, first, and dispositive of this case, a written contract does, in fact, govern this dispute. Therefore, regardless of whether Missouri law applies, Virginia law applies, Ohio law applies, it really doesn't matter because M&P timely filed the collection action under any of those state statute of limitations. But even so, the trial court did correctly apply Taylor in this case. The holding in Taylor is very clear and unambiguous. The credit card debt action accrues where the payments are to be made. That's a law we were given by the Supreme Court. It's a law that we have to apply and follow, and it's very clear and unambiguous on its face. Now, even if M&P had filed a time bar debt, and even if there wasn't a written contract, which both we argue there are, Ms. Jones presented just no evidence there was a knowing violation. And here, when you're dealing with statute of limitations violations, you have to show that there was a knowing violation. And that couldn't exist here because the law was unsettled at the time. Even as late as 2011, the courts were applying Ohio statute of limitations to these type of actions. And finally, M&P is entitled to the bona fide error defense because it had reasonable procedures in place to prevent violations such as the ones alleged here. So, with respect to the accrual of the jurisdiction, the trial court properly found, based on Taylor, that it was Missouri. The central holding in Taylor versus First Resolution Investment Corporation is, and I quote, "A cause of action for the failure to pay a debt accrues in the jurisdiction where the debt is to be paid." That is the guidance provided to us by Taylor. Now in Taylor...
But where the debt is to be paid, that's still, to some degree, a little ambiguous because, you know, it's so weird in today's society. We have Venmo, we have, you know, PayPal, we have all kinds of stuff that goes on. So where the debt is to be paid, that could be different than where the payment is received.
It could be. There are many ways to make payments. Fortunately, the guidance we have from Taylor is the guidance that we have from the Supreme Court in Taylor. I will say that in coming to its conclusion, the Supreme Court in Taylor did consider, for example, a post office box where a payment was to be made. It considered, quote, "the central location where a bank received payment," which in this case seems like a central processing facility. So it did consider specifically where the payments were sent in its holding. And that's the guidance that we have.
And Taylor, remind me, were there separate incorporations and principal place of business?
The payment in Taylor and the payment was sent and the headquarters were both in Delaware. So we didn't have this disparate situation.
That's what I was recalling, but I wanted to make sure.
Correct, yes. So
that could be a different situation.
it could be different, but I will say the court in Taylor did consider, again, the P.O. box and the central location where payments were sent.
But that's still in the same state.
Those were persuasive authorities that I considered, so I don't recall the specific facts of those persuasive cases that I considered.
All right, thank you.
So even if the trial court misapplied the statute of limitations of Missouri, it really is of no import, and this court should still affirm the decision because the dispositive issue is that there is a written contract here. No matter which state law applied, M&P timely filed a collection action. Now, Ms. Jones significantly does not dispute that she received a credit card agreement, that she signed it and returned it to Capital One. A copy of that was provided to the court. There's a front and back of the solicitation package. There's also a copy of the coupon that was detached, signed, and mailed back to Capital One. So this package was received by Ms. Jones. She signed it, and it doesn't dispute that she did just that. Now, the solicitation package includes her interest rate. It's 11.3 plus prime. It references the acceptance certificate that she signed, and it also references a customer agreement. This document is a written agreement, and there's simply no evidence to the contrary. Now, a lot of times where cases have found that a written contract did not exist, those are dealing with third-party debt buyers. They simply don't have the documents. But again, we're not dealing with that here because Capital One opened the account and was the owner of the account. So the very issue, it was addressed in a case cited in our brief, Unifund CCR Partners versus Piezar. Now, there's one significant difference in that case. There was no signed agreement. So they don't have the cardholder's signature like we do here. But even without that, the Piezar court found there was a written agreement because it said that the debtor's conscious decision to use that card, which Ms. Jones undisputably used the card, it is an agreement to accept the terms and conditions of the written account agreement at the place at the time, which is what we have here. So we have a step even above Piezar. We have the written agreement in evidence. So other than general contract law, such as Reyes, which is simply just the general elements of a contract, Ms. Jones really doesn't provide any case law or authority showing that an oral contract exists here. So we asked that the court were to affirm on that basis as well. Now again, even if the first two elements were not agreed with, there's no FDCPA violation because really you need a knowing violation. Justice Sotomayor in Midland Funding versus Johnson even acknowledged this, that a knowing violation when it comes to the statute of limitations. So when we're dealing here with the application of the statute of limitations, you have to have a knowing violation. You can't have that here, as outlined in several of the cases in our brief, the Almond case. When the state law is unclear, you cannot have a knowing violation when the highest state court has not spoken.
Well, I thought that Taylor said the exact opposite of that, though.
I don't believe so.
I thought it said it was a strict liability.
Not with respect, with the cases that are cited in our brief, it's not with respect to the statute of limitations. Now, I do agree that there is a strict liability element to the FDCPA, but here it's not applicable. You need a knowing violation, which you can't have when the state law is simply unsettled. And again, in Taylor, the trial court in 2011 was still applying Ohio's statute of limitations. So the law has been unsettled, although I would argue that Taylor has clarified that to the extent that it did. And Chief Justice O'Connor's dissent in Taylor actually notes how unsettled Ohio law has been. She actually advocated there was ample authority in the Taylor case for bringing the suit and applying Ohio's statute of limitations. So really there's no guiding case law at the time MMP filed this case showing that Virginia law would have applied. So there simply can't be a knowing violation. And even if there was a knowing violation, I would also argue the bona fide error defense would apply because there were reasonable procedures in place that MMP had in place to prevent such violations of the statute of limitations. So as to the second assignment of error, Ms. Jones makes a couple of arguments regarding Capital One Bank. First, that it's a defunct entity. Second of all, it lacks standing to sue Ms. Jones. And third, that it's not a real party of interest. And I would say none of those arguments have legal merit. Now, the key issue I want to focus on with respect to the FDCPA is whether the creditor made a material misrepresentation. So Capital One is not seeking to collect the debt. The collection action was dismissed before Ms. Jones raised any issue regarding standing. So Ms. Jones, or Capital One would not have had a chance to amend the complaint. But regardless, we're looking at a material misrepresentation. So first of all, Capital One Bank is not a defunct entity. 12 CFR 5.24I, it converted to a national bank. The CFR states it is considered the same business entity. So it's not a defunct entity, it continued on. Regarding standing, Capital One was, and remains.
If it continued on, though, are you saying that case law provides that it can still continue using the state bank name?
I don't. So what I would argue is that at most it was dropped by mistake off of the complaint, which is a misnomer. It's been several other cases that had very similar scenarios. For example, there's a case, D&E Builders. So in D&E Builders, is cited in our brief, they filed the complaint, I think, in D&E Construction. It was the wrong name. But with respect to the FDCPA violation, it wasn't a standing issue, it wasn't a real party and interest issue, it was this a material misrepresentation? And the court answered no. And here, Ms. Jones didn't testify that she was confused, that she didn't know who was suing her. There's just there's no evidence of that. For example, also in the NCO Portfolio Management, they left off the .inc or comma inc. They sued in the name of NCO Portfolio Management. Again, the court said, no, this is at most a misnomer. It's not a standing issue, it's not a real party and interest issue, was there a material misrepresentation by the creditor? And the answer was no. And here we have almost the analogous situation, is that we dropped off the USANA. So that at most, rather than a material misrepresentation, it was not a material misrepresentation, it was simply a misnomer, which the trial court properly determined.
Weren't they both used though at one point?
They have been, the complaint was filed in Capital One Bank. They did eventually, they started using Capital One Bank USANA, but were unable to amend the complaint at that time since it had been dismissed at a certain point. So they have used the USANA since.
And we'll go through the record thoroughly, obviously, but of course the other side is saying it was not dismissed at the time.
Correct, and the record will show when it was first raised. I don't have the date in front of me. But the collections complaint was dismissed early on in this case. And the new claims were raised subsequently. If there are no further questions, I will conclude.
Thank you. You have your full 5 minutes for the rebuttal.
Thank
wish
you.
to take it.
I'd like to just go over some of the points that I was writing as Ms. Jared was talking. So the first question is the assertion that the receivables in this case were not sold. They were sold. In fact, there is clear evidence from Ms. Amesler that the receivables were sold, and that Capital One Bank, USANA, did not have any right to the receivables or to any of the money collected. Place of payment is, again, they keep insisting that the place of payment is the P.O. Box, whereas, as we pointed out in our brief, the various agreements themselves provide for alternative methods. The account statements themselves say you can go online at the account. We presented evidence that the CapitalOne.com is the site itself has a Virginia address as its registered address. So if you want to go for a payment being made on the website, it would be in Virginia as well. Third point is FDCPA being a knowing violation. It simply isn't a knowing violation. There is plenty of law that, as Judge Carr pointed out, that it is a strict liability statute. There is no exception for specific cases like statute of limitations. In fact, there is law to the contrary that says mistakes of law do not qualify as a bona fide error defense. The fact that this was a surprise is a little confusing, since the borrowing statute has been on the books since 2005, well before this case was filed, and MMP has not cited to any law that says a statute shouldn't be enforced, or they're not subject to the statute, or shouldn't recognize it if a court hasn't considered it or applied it in this context. In fact, when MMP talks about maintaining procedures to support its bona fide error defense under the FDCPA, their procedure is actually just the opposite. It would never support a bona fide error defense because it requires the application of a statute of limitations which does not consider the borrowing statute. So the procedures do, in fact, negate any claim for bona fide error defense. The solicitation package, the court should know, and we pointed this out in our summary judgment briefing, is that Capital One itself made various claims. At least the current package that they claim is I believe the third revision. They first claimed and testified that they had found the solicitation package that was mailed to her. They changed their mind at least twice and submitted various versions of this package. And I do not believe that there is evidence that Ms. Jones admitted that she received the solicitation package, as they have said. Certainly there is this little coupon type thing which shows her signature, her maiden name signature on it. The Pizer decision is the decision that M&P is citing was actually replaced. On reconsideration, the court issued a new opinion, so that is from the earlier opinion. And again, the 11th District in that case did not apply the standards stated by the Ohio Supreme Court in Reyes. There is no such analysis there as well. Amendment, the idea that they didn't have any time to amend, if you look at the timeline, there was clearly, they started using Capital One Bank USA NA's name well before the complaint was dismissed. So if that was true, they had sufficient time to, in fact, amend the complaint. Defunct does not use, I think, I forget which one of you asked this question, but
Doesn't matter, we're all a team.
right. Well, there is this little bit of a misleading thread there, where they say, well, Capital One, there was a Capital One Bank, and then it became Capital One Bank USA NA, and just because the reg says that it continues, the succeeding entity has all the rights of the prior bank, there is absolutely no law or citation that they've said that they can continue to use the old name. Particularly in this case, when someone else.
I wanted to let you finish that thought, but you're over your time.
Okay. Just the idea that they have, that the use of the name, particularly in this case, is clearly inappropriate, where another entity has registered that name as a registered word mark. Thank you.
Thank you both for very good arguments. We will take this matter under advisement, issue a written decision in due course. It will be mailed to both sides as well as posted on our website and that of the Supreme Court. Thank you.
Thank you.